Hello everybody, welcome to another video from freedqinfo.com. In this video, I'm going to be talking about Alina Garcia, who's an attorney for the Civil Service Commission, and how she manipulated and deceived the court by filing false statements in order to defeat an applicant's case. So before we get to her, let's talk about some disqualification letters so we could reach that conclusion. So right over here, we've got the disqualification letter of Victor Luna, and I spoke about Mr. Luna in a previous video. So here it is. We know that that's an illegal disqualification letter. Here are the decision documents, and again, I want to concentrate right here. On July 7, 2010, after a review of the record presented, the commission concluded that there were factual issues regarding applicant's disqualification for the position that needed to be resolved. The issue that needed to be resolved is pretty much right here. This is the illegal disqualification letter. So they needed to resolve that. And let's see here. So they, right here, we hereby reverse the disqualification. Notice the signatures. You've got Nancy Chaffetz, Simon P. Gordine, and Rudy Washington. And the date is December 29, 2010. Let's fast forward over to their legal documents, and I went into detail about this particular page in another video, so I'm going to kind of skim through it. Again, Victor Luna was not legally disqualified because he was not given a written statement of the reasons for his disqualification before his disqualification, or afforded an opportunity to make an explanation and to submit facts in opposition to his disqualification as required by law. So then they talk about civil service law. Again, it says no person shall be disqualified. And this is the most important section. This sentence right here, it says, in the case of NYPD candidates, the commissioner of DCAS has delegated its authority to qualify candidates for the position of police officer to the NYPD, and NYPD's processing of potential candidates, as are all candidates for all positions disqualified by DCAS, is bound by the same dictates of Civil Service Law, Section 50.4 and 55 RCNY, and that's the rules of the City of New York. And the key words here are, as are all candidates for all positions. So all meaning every single illegal disqualification. So let's go to the next page. Civil Service Law and the rules of the City of New York require NYPD to provide prospective candidates such as Luna. Again, prospective candidates such as. So that means Luna and pretty much everybody else who got the illegal disqualification letter. And what were they supposed to receive? They were supposed to receive the NOPD. It's written right here. The notification of proposed disqualification before a final notice of disqualification is issued. And they talk about how it's required by law. Again, right here, required by law, required by law. And finally, this is very, very important, the conclusion page. Alternatively, the Civil Service Commission requests that petitioners, when they talk about petitioners, they're talking about NYPD, requests for relief be denied in all respects based on their violation of the legally established civil service disqualification process, which requires notice and an opportunity to respond before a disqualification is final. And this is dated August 2011, and it's signed by the attorney for the Civil Service Commission, which is Alina Garcia. All right, now let's fast forward to another applicant over here. That's Mohammed Ahmed. And again, I did a video about him as well. And you see here is his illegal disqualification letter. Over here, we have the decision document. And right here, this section right here in the middle, on July 20th, 2012, after a review of the record presented, the Civil Service Commission concluded that there were certain issues that needed to be resolved regarding applicant's disqualification, including the issue of whether applicant's disqualification was rendered in accordance with the requirements set forth by Civil Service Law, Section 50.4. So they're basically talking about the disqualification letter. They know it's illegal, and they were asking NYPD to explain how that disqualification complied with the requirements. And of course, it did not. So the last page of the decision document, for the reasons set forth above, we hereby reverse applicant's disqualification. Notice the signatures: Nancy Chaffetz again, Rudy Washington, and Charles D. McFall. That is in March of 2013. Now we move over to the Civil Service Commission's verified answer, where they basically defend the decision to reverse the disqualification, and they talk about justifying the fact that they held a hearing. So look at over here, number 27. Admits the allegations contained in paragraph 40 of the amended verified petition. Now, the amended verified petition, that's the document that was submitted by NYPD. So they're admitting to something about paragraph 40. And here is the most important part. To the extent that the Civil Service Commission hearing was held pursuant to section 2-02D of the Civil Service Commission's rules of practice, except notes that the Civil Service Commission hearing was also pursuant to New York Civil Service Law section 50.4, which states that no person shall be disqualified pursuant to this subdivision unless he has been given or actually afforded an opportunity to make an explanation and to submit facts in opposition to such disqualification. So again, they are justifying the hearing by claiming that they held the hearing pursuant to Civil Service Law 50.4, basically to enforce that law. Now, that law was written for everybody. It's a state law. It covers all applicants. So as you remember, as I just talked about in Victor Luna's case, the Civil Service Commission argued that all candidates are protected by Civil Service Law section 50.4. And let's see the date here, January 2014, signed by Alina A. Garcia. Again, that is the attorney for the Civil Service Commission. And here is her verification document. Now, the verification document basically means that she is swearing to the truth to these legal arguments and these legal documents. And let's read what it says. Alina A. Garcia, being duly sworn, states that she is the Executive Director and General Counsel of the New York City Civil Service Commission. She is duly authorized to verify this answer in opposition to basically NYPD's documents on behalf of Civil Service Commission, and that she has read the foregoing answer, and with respect to the actions and determinations attributed to the Civil Service Commission, she knows the contents thereof to be true. So basically, she's swearing that the actions and determinations and the decisions by the Civil Service Commission with regards to their decisions in the Ahmed case are true. I mean, here it is. Here's the verification. She basically swore to it. She's an attorney, so she's authorized to make that that statement. And again, that's January 6, 2014. She just swore to the fact that Mohammed Ahmed's disqualification was illegal. The Civil Service Commission reversed it because it was illegal, and they basically enforced Civil Service Law Section 50.4 on his behalf. So now let's move over and let's look at a candidate that's sandwiched in between Victor Luna and Ahmed. So let's look up again at here. You have Ahmed, right? Here you have this gentleman called Travis Griffin, and here you have Victor Luna. You pretty much notice that these are the same exact disqualification letters. Let's look. The only difference between Mr. Griffin is that Mr. Griffin's disqualification letter was from Department of Probation. So the only difference is the agency name, but the disqualification letter is basically exactly the same. So look, the results of the psychological evaluation have found you psychologically not qualified for the title of probation officer. This determination was based on evaluation of your psychological test and interview, which found personality traits incompatible with the unique demands of the position of probation officer. And then it says, if you wish to appeal your disqualification. No, if you wish to appeal your disqualification, they're telling him you've been disqualified. This is not an NOPD, okay? He did not get a notice of proposed disqualification. Neither did Ahmed over here, as you can see, and neither did Luna right over here. So here we have Travis Griffin. He got the illegal disqualification letter. All right. Here is the decision document. All right. Now, I'm letting you know up front that they actually affirmed. So they agreed with the decision. And just look at the bottom line here, or about bottom paragraph. We have carefully reviewed the results of the clinical testing, the report of the correction department interviewer, documents submitted by applicant, and the report of the correction department consultant. We find that the evidence before us establishes a rational basis for the conclusion of DOC that applicant is not psychologically suited for the position of probation officer. Now, just in case you're confused, because this is actually a Department of Probation job, It was Department of Correction that did the psychological because they were subcontracted by DOP to do their psychologicals. So again, they're saying here that the Civil Service Commission, that they reviewed all the documents. And look, this is the last page. We further find that the record before us does not raise any issue that requires a hearing. They're saying they found nothing in this guy's record that warrants a hearing. Now, I object to that because the issue is Civil Service Law Section 50.4. It was an illegal disqualification in violation of that law. Look at the disqualification letter. This is the same illegal disqualification letter that the other guys got, meaning Ahmed over here and Luna over here. So Travis Griffin got the same exact illegal disqualification letter. And now let's look at the documents. So Travis Griffin took these people to court to basically get, his disqualification reversed. And let's look over here. Number 46, after carefully reviewing the entire record before it, including petitioner's clinical testing, reports, etc., 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 CSC affirmed the determination. Okay. Number 47, after carefully reviewing the results of the clinical testing. So again, they're basically saying they looked at all the documents very carefully. They reviewed everything. All right. Now note, they wrote over here, we find that the record does not raise any issue. Okay. They're completely ignoring the fact that this guy Griffin got an illegal disqualification letter. All right. Now let's look at the one of the final pages over here. Number 49, the petition fails to state a cause of action. Well, I beg to differ. The cause of action is Civil Service Law Section 50.4. All right. Number 50, the undisputed record established a rational basis for the affirmance. Again, I challenge that. Okay. The undisputed record established a rational basis for a reversal pursuant to Civil Service Law Section 50.4. Look at this. Accordingly, Civil Service Commission's decision to affirm petitioner's disqualification, which was based upon a thorough review of the record, should not be overturned. Again, I challenge that, all right, because if you review the record, you see that Griffin got the illegal disqualification letter. So therefore, he should be protected by Civil Service Law Section 50.4. Now here, this is where it gets very scary. Number 51, the Civil Service Commission's actions were all respects legal, proper, reasonable, and in conformity with all applicable laws and regulations. Okay, that's impossible. Why? Because Civil Service Law Section 50.4 protects Mr. Griffin. Look at the names of these other people that received the protections. Ahmed, Patterson, Luna, Lopera, Meehan, LaRouche, D'Agostino. So on behalf of Mr. Griffin, we need an explanation as to why the Civil Service Commission completely ignored the fact that his disqualification was illegal and he should have been protected by Civil Service Law Section 50.4. Now, let's look at the verification. You have here, look who it is, Alina A. Garcia being duly sworn, all right, verified answer, knows the contents to be true, except to the matters therein alleged upon information and belief as to those matters. She believes them to be true, all right. Here's her signature. 2012. Alina A. Garcia is basically now swearing that the determination in the Griffin case was basically lawful and correct and reasonable. That's impossible because I just showed you over here. Look, Alina A. Garcia, she just swore that the reversal for Ahmed based on the illegal nature of the disqualification, she swore that the decision to reverse Ahmed was correct and true. All right, here we go to the bottom. In the Luna case, the conclusion, based upon their violation of the legally established civil service disqualification process, which requires notice and an opportunity to respond before the disqualification is final. That's, look, 2011, Alina A. Garcia. Over here, for Ahmed, January of 2014. Now, in between, you have Griffin. All right, look at the date, 14th December 2012. Okay, this is impossible. Okay, as a matter of fact, what Alina A. Garcia has done here is she had filed false statements. I mean, this is basically perjury. All right, she swore that Griffin's disqualification was legal and proper and was, per civil service law, etc., etc. That's not true. It's totally not true. So she has deceived the court and manipulated the court by submitting this sworn statement. For what purpose? Well, to defeat Griffin's case in court. Now, what is scary about this? Well, this is to submit sworn statements which are false in a court of law is perjury. Okay, so that's a felony offense. So here we have an individual who is committing a felony offense just to prevent some guy from getting a job and to defeat his case in court. This is particularly disturbing. I mean, in the private sector, it's bad enough that people discriminate against you for various reasons. But here we have an individual who is specifically committing a felony tailored to, getting rid of and defeating another applicant. This is what is very, very disturbing. So I'm going to take a break right here, and I will talk about this in more detail with additional videos. Thank you for watching.